Good evening to the participants of the SLW646, that is Advanced International Dispute Settlement Law. Yes, anyone can unmute and read what I posted on the screen. The participants, anyone can unmute and read what I posted on the screen. Okay, let me read it. We focus on the three outcomes of interest. First, when do states choose to revise the territorial status quo through negotiation instead of force? Second, when are the states able to reach a final settlement? Third, when do states prefer a process of legal dispute resolution, that is, adjudication or arbitration, to bilateral negotiations? To answer these questions, we argue that when the legal principle relevant to the disputes are ambiguous and clearly favors one side, a law-based focal point will emerge. This focal point, in turn, facilitates the settlement process by helping leaders overcome distribution problems, a central obstacle in reaching a final agreement. We find strong and consistent empirical support for our hypothesis regarding the international law and peaceful dispute resolution. So what we are studying is peaceful dispute resolutions in international law. How international disputes will be resolved, by what means, and that we are dealing it. And there we come across a Manila Declaration also. And let us see that what is the Manila Declaration says in this class. Participants, anyone can unmute and read what is posted on the screen. Participants, are you hearing me? Yes, let me read it. Manila Declaration on the Peaceful Settlement International Disputes. So there is bilateral relations, multilateral relations, and the declarations, and the parties to the declarations, they will follow the means of declaration in any dispute between or among the states occurs. Now let us see what is the declaration says. Introduction. The Manila Declaration on the Peaceful Settlement of the International Dispute, and hereinafter we can say Manila Declaration or Declaration, was approved by the resolution 37/10 under the item Peaceful Settlement of the Disputes between the states by the United Nations General Assembly on 15th November 1982. So Manila Declaration is made by the UNGA, that is the United Nations General Assembly, on 15th November 1982. On the basis of text prepared by the Special Committee on the Charter of the United Nations and on the strengthening of the role of the organization in its 1980 session held in Manila. Manila, where is the Manila? The Philippines. It is in the Philippines. The declaration is the first important instrument of the work of the Special Committee on the Charter of the United Nations and on the strengthening the role of the organization, and one of its significant achievements. So an international dispute, peaceful dispute settlements through the Manila Declaration, and which is made by the United Nations General Assembly on 15th November 1992, and the main purpose of it is to strengthen it is based on the Special Committee on the Charter of the United Nations for what? For strengthening of the role of the organization, and one of its significant achievement in resolve the international dispute by peaceful means. The Manila Declaration was elaborated in the initiative of non-aligned countries like Egypt, Indonesia, Mexico, Nigeria, Philippines, Romania, Sierra Leone, and Tunisia. So it is initiative of the non-aligned countries. These countries are non-aligned countries. Now let us see what is non-aligned. Does it mean that they are not the party to the declaration, or let us see, are they anti to it? Now let us see whether what it says. Non-aligned countries. Yes, here non-aligned non-aligned countries. Yeah, currently every African country except South Sudan and Western Sahara is a member of the non-aligned movement. Means they are not agreeing to that one. So these are countries. They said Algeria, Angola, Benin, Botswana, Burkina Faso, Burundi, Cameroon, Cape Verde. So they are the non-aligned. What is mean by the country is non-aligned in the sense that means it does not support or depend on any powerful country or a group of country. The smart vocabulary related words is phrases unbiased or impartial. They don't want to be among them. They doesn't support them and depend on any powerful country or a group of countries. They don't want to be they want to be the neutral, and they want to be unbiased, and they want to be impartial, and so that they would not come under the clutches of the powerful countries. So that is the non-aligned countries. So now let us see, for our sake, is non-aligned countries mean they don't come under the clutches of the such a powerful countries is the Egypt, Indonesia, Mexico, Nigeria, Philippines, Romania, Sierra Leone, and Tunisia. So United Nations New York, that is Mr. Romulo, Philippine, this initiative of the non-aligned Caribbean, non-aligned countries might explain why the initial draft contained so many references to equal rights and self-determination of the people. So this Manila Declaration elaborated the initiatives, and it is strengthening the role of the committee, there is a special committee made for resolve the dispute in a peaceful manner in international level. So here the New York, the United Nations, Mr. Romulo, the Philippines, the initiative of the non-aligned countries might explain why the initial draft contained so many references to equal rights and self-determination of the people. So there are many equal rights are there, and self-determining of the people are there. For any country, either in the declaration or a protocol or whatever it may be there, if it is a member country, you should have to follow it. If they don't want to make the member of country, okay, you can make the non-aligned countries also. You need not come under the clutches of the powerful country. You can be unbiased, impartial, and want to maintain their own independence. So, the need for all states to desist from any forcible action which deprives the people, particularly under the colonial and racist regime and other forms of alien domination. And here, a powerful country will not force a weak country for accepting a particular thing, or if they want to decide anything, it should be followed. No, if it is the country doesn't want to follow it, they can go for the appeal. If in the peaceful manner, they can resolve the issues. And the best one is they can approach the UN General Assembly or the Security Council to resolve the issue. And they will sit together and they will make it out, yes, this should be your amicable solution for this dispute. So what I want to say is there is a colonial and racist regimes are there, and other forms of the alien domination is there, of their inalienable rights of the self-determination, freedom, and independence. So the right to self-determination should not be violated, and freedom and independence should not be attempted. And in that way, the amicable solutions can be resolved by this declaration. right of these people so struggle at the end and to seek the receive support. Such references more strongly worded in the beginning were softened in the presence of the negotiation that led to the adoption of the declaration by the General Assembly by consensus. So the parties they will take the consensus of it, whatever the provision is made in the declaration, and it will not be a one-sided one, or it will not be in favor of the powerful country and disadvantage of the weak and weak countries. No, it should not be in that manner. It is important to keep in mind that the context in which the Manila Declaration was negotiated and adapted was that of the difficult relations between the East and West. When the Manila Declaration is made, there is a different of conflicts between the East and West would be there, and of the intent of the non-aligned countries to seek clarification of existing international law in conjunction with their aspiration. So some of the countries are non-aligned countries. They don't want to become under the clutches of the powerful country. They want to be unbiased and they want to make it neutral also. So it depends upon the country whether you want to be part of it or non-aligned. You will be non-aligned country. The discretion is given over there. Why all these things should be necessary? These declarations, Raymond Cosmos. Why
Yes, Prof.
these declarations and conventions will be needed? Yes.
To resolve the disputes in a peaceful way.
The motto of them is whatever the dispute would be there in international arena, it will be resolved by peaceful means without using any force. And the justice seems to be done, and justice to be done, and it seems to be done also there. So that also is another point. They can make it out. So that is the reason these are the declarations, conventions, and charters. These are the necessary, essential when such a disputes arises, then how it could be resolved. Though nevertheless, one should not underestimate the fact that the approval of the declaration by the consensus brought together states and had already consented to the content of the Article 33 of the Charter of the United Nations, and states which subsequently became members of the United Nations. So Article 33 will make it out. Those states wants to make it out. Yes, let them make it out, because and later they become the member of the United Nations. Hence, the declaration was adopted with the active contribution of the United Nations members belonging to the various groups existing at that period. So, the Manila Declaration is almost all the countries of the United Nations, they followed it and they are the member of the such a declaration. For the first time, the normative text develops a comprehensive plan and consolidation of the legal framework of the peaceful settlement of the international disputes. So a special committee is made and they made the report, special report, and later on it becomes the Manila Declaration, because if the place is Manila is there, hence the Manila Declaration. And where this Manila city is situated, in which country?
Philippines.
Philippines. It is there. So the declaration builds upon and promotes a general international law. The Charter of the United Nations, in particularly Article 33, and other international instruments such as the Declaration on Principle of the International Law concerning friendly relations and cooperation among the states in accordance with the Charter of the United Nations General Assembly Resolution 2625, that is how many 10, 10, 20, 25 for 24th October 1970. The American Treaty on Pacific Settlement Pact, that is the Pact of Bogota, that is 30th April 1948. The European Conventions on the Peaceful Settlement of Disputes, Strasbourg, 29 April 1957. And another, can you tell me why the Strasbourg is famous in international law?
Pass on, sir.
See, when we are studied for the human rights violation control and recognition and prevention of the violation of the human rights in the entire world, one court cannot decide it, like ICJ. So with that, they made three regional settlement courts are made. So for the American, the US based is there in Washington DC. That is a African court for the violation of the human rights. And when you come to the Europe regional court is there in Strasbourg, which is in France, to preserve the human rights violations. And for the African continent, where is that human rights violations court? Control it in African
Ethiopia.
continent.
Ethiopia.
That is Ethiopia's African Union headquarters is there.
Okay.
Arusha, what is there in Arusha? Is it not the African Human Rights Court tribunal is there?
There is.
There is. So for African, it is an Arusha given. For European, it is Strasbourg, Germany, France is given. For the US side, American side, any human rights violations are there, it is Washington DC, and where the cases will be filed over there and judgment will be given in the basis of the human rights violations. Okay? So here,
Yes, Prof.
international disputes are concerned, there are various international instruments are there. Like just now we studied, one is the Manila Declaration, it is there in Philippines, and another is Declaration on the Principle of the International concerning the friendly relations and cooperation among states in accordance with the Charter of the United Nations General Assembly, and the American Treaty on Pacific Settlement, the APAC Bogota, the European Conventions on the Peaceful Settlement of the Disputes, Strasbourg, General Act for the Pacific Settlement of the International Dispute, Geneva. These are all the Pacific Settlement of the International Disputes in different places, and revised by the United Nations General Assembly in 1949. And sometimes these declarations are backed by the UN. And some declarations will be bilateral or multilateral. Those who are the parties to the declaration or the charter, and there is the binding on them to resolve the international dispute in a peaceful manner. Is it clear?
Yes, Prof.
Different
Yes, Professor.
places, different declarations are there. And the place where it is there, the case will be settled in that. Because, for instance, Manila Declaration would be there, they will base it. Generally, it's the Manila, means it's the Philippines, the dispute will be resolved. Because it is the basis there. So the declaration contains a preamble and two operative parts. Number one, part one encompasses the applicable principles and rules of peaceful settlement of international dispute. As such, part two is devolved to the ways and means provided by the Charter and by the general international law, with emphasis on the role of the competent organs of the United Nations to this effect. So one is preamble, two parts. One is the principles and rules of peaceful settlement of the international dispute. There is one. And the second part is the means provided for by the Charter by general international law, with the emphasis on the role of competent organs What are the competent organs of the United Nations to this effect will work in the resolving the peaceful manner the international disputes. So let us see the preamble. The declaration reaffirms two fundamental principles to the Charter, namely the obligation of all the states to settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered, and obligation for all the states to refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purpose of the United Nations. So in the preamble, it is made it very clear. It is the member states and their obligation on them, whatever the dispute would be there in the international arena, it should be resolved by the peaceful means. And how? By keeping the internal peace and security, maintaining the internal peace and security and justice and are not endangered, and obligation of all the states, those who are the member for the declaration, to refrain in their international relations, means refrain means stop, hindrance, full stop, the international relations from the threat. There would not be any threat or use the force against the territorial integrity of each country or a political independence of any state. So in any other manner, you should not be inconsistent with the purpose of the United Nations. So that is the clearly given in the preamble. The preamble underlines the fact that the Charter of the United Nations embodies an essential framework and the means for the peaceful settlement of the international disputes. It further reiterates the principle of non-intervention and refers to the aforementioned declaration on the principle of international law concerning the friendly relations and cooperation among the states. In any manner, whenever the international disputes are resolved, it should be resolved in the peaceful means, number one. Number two, there would not be any external aggression or the violation on the integrity of the states, or suppressing the state, or making the apprehension, or making them fear. This should not be there. It should be in contravention with the charters of the UN. So they clearly mention how it could be implemented. The preamble also stressed the principle of equal rights and self-determination of the peoples and need for all the states to desist from any forcible action which deprives the peoples, particularly peoples under the colonial or racist regimes, other forms of alien domination of their inalienable rights to self-determination, freedom and independence. So, it also made it clear in the preamble of the Manila Declaration that the amicable solution would be resolved over there, but without attacking on the subjects of the other country, whether they are the people of the racist regime or ruled by the colonial government or other form of alien dominations or their inalienable rights which cannot be taken away. The freedom could not be taken away and independence also should not be taken away. It concludes by recalling the normative efforts of the international society with regard to the principles and rules concerning the peaceful settlement of the international disputes and expresses the intention of the drafter to encourage the progressive development of the international law and its codification. Nevertheless, until now, the International Law Commission did not produce such a general instrument to this effect. But they made the several things, but a concrete declaration till today is not made. So that is the preamble, all the says about the Manila Declaration. So here again you would say in part 1, identification of applicable principle and rules. What are the applicable principles and rules should be applied for resolving the international dispute with a peaceful settlement? So in part 1, Participant, can anyone unmute and read this one?
In part 1, the declaration enunciated the principle of prevention of disputes that are likely to affect friendly relations among states and refer to good faith. It is significant that the principle of good faith appears expresses verbs 5 times in the text. Part 1, para 1, 5, and 11. Part 2, paras 2 and 6. Furthermore, the text emphasizes the state have the free choice of means. Part 1, para 3, and that dispute shall be settled exclusively by peaceful means.
So, in the part 1, they clearly enunciated what are the principles should be followed and what are the prevention disputes should be there and how we can make the friendly relation among the states and making in a good faith. So it says that principles of good faith appears expressis verbis, that is, it should be expressly shown over there. And of course, we cannot remember the 5 times in the text, paras and so thing. But the text emphasizes that states have the free choice of means and dispute shall be settled exclusively by peaceful means. So that is the gist of it. As far as the applicable law is concerned, para 1, para 3, part 1, para 3 recalls the relevant obligation in the Charter, the principle of justice and those of general international law. So generally, the applicable law is as envisaged in the Charter, are clearly said in the Charter. And there it will follow the principle of justice and international law instruments gist also. Part 1 and para 5 repeats the non-exhaustive list of means, that is the negotiations, inquiry, conciliation, mediation, arbitration, judicial settlement, resort to the regional arrangement, or agency or powerful or peaceful means of settlement, including the good offices. What these are all? These are all non-exhaustive list of means where the international disputes can be resolved. So they said negotiations by inquiry, by conciliation, by mediation, by arbitration, by judicial settlement, resort to the regional arrangement, or agencies or other peaceful means of settlement, including the good offices also. While part 1, para 13 explicitly excludes any method of settlement, excludes, they said, any method of settlement involves the use or the threat of force. If any violation should not be there, any threatening would not be there, any coercion would not be there, and use of threat would not be there, any apprehension would not be there. So the express reference to good office appears to be the novelty in relation to the wordings of the Charter. Yes, in the Charter, the novelty is good office. The method of settlement involves the wording of it appears is good office is a beautiful wording that here. Because generally a neutral state come forward and they will invite both the parties to use his own office and sit together and resolve the issue, and we will act as a mediator between you. So on the other hand, in part 1, paragraph 10, the text seems give preference to a meaningful negotiation. Obviously, in the sense that International Court of Justice utilize the expression, and this can be understood in the context of the circumstances prevailing at the time of the adoption of the declaration. So they said it is a meaningful negotiation that should come out. not something which is conditional. And it depends upon the context prevailing at the time when the adoption of the declaration is made, and that is a very important factor, especially in resolving the disputes. Part 1, para 6 stresses the role of the regional arrangements in the process of the peaceful settlement of disputes, recognizing a temporal priority, notwithstanding the primary role of the Security Council. But more explicitly than Article 52, para 4 of the Charter, it adds that this does not preclude the state from bringing any dispute to the attention of the Security Council or General Assembly. See, the Manila Declaration will not make it any such a direction that if a dispute would be there resolved, it should be resolved only by the Manila Declaration. No. It adds that it does not preclude, means it will allow the state to bring the dispute to the attention of the Security Council or the General Assembly. So, Manila Declaration is there, no doubt, for the states. It doesn't mean that we cannot approach to the Security Council or General Assembly. Suppose if the declaration, if they have given it by using the peaceful means, but if any one of the party got aggrieved by the decision, at that instance they can approach to the Security Council and the General Assembly to resolve it by following the international norms. So the text also provides that states parties to an international dispute shall refrain from any action that may aggravate the situation. Though the state will be refrain, they should not use any threat, they should not use any force, and they should not aggravate the situation. Like adding the fire, adding fuel to the fire. Raymond, what it means by adding fuel to the fire? Yes. Aggravating it.
Person, sir.
Adding the fuel, fuel means oil, to the fire. If you add the fuel to the fire, what will happen? It will burn. Explosion comes, or light comes, or fire comes out. So the state should not, the situation should be aggravated. No, it should be amicably solved. So calls on the state to conclude agreements or include the agreement's effective clauses for the peaceful settlement of the dispute. And you cannot remember the para 1, para 9, no. You can say charter means Manila Charter. Declaration means Manila Declaration here. So the Manila Declaration, a different provisions also make it out. They should have to settle the dispute but not to aggravate the situation or amplify the situation which leads to disaster means. Amplifies the declaration friendly relations and invitation to resort to a peaceful settlement of dispute in the exercise of the right to self-determination. So, peaceful settlement and without adding the fuel to the fire or aggravating the situation, they are not supposed to do it, and that is clearly given in the agreement of the charter. So by following that one, a peaceful settlement of the dispute in the exercise of the right of self-determination. So the self-determination right also to be protected. They will not be incriminated. So these are the idea behind it. So if you see the part 2, the role of the United Nations and its organs, the second part of the declaration exposes the ways and means by which the United Nations seems can contribute to the peaceful settlement of the international dispute. It gives the means and ways how to proceed. Specific presentation are made with respect to the role of the 4 principal organ whose contribution is considered to be important, namely what organ? General Assembly. It will clearly gives what it should be done and what it should do. The Security Council, number 2, the 3 International Court of Justice, and the fourth is Secretary General. These are the four organs. They will try to make it resolve the issue in peaceful settlement by following the declarations. In addition, the declaration specifically mentioned the role that the subsidiary organs established by the General Assembly and the Security Council may have the process of peaceful settlement of international dispute. Even the Security Council or General Assembly, which made other sub-organs to function in the peaceful settlement of the disputes, yes, they will encourage, they will pass on, they will give the direction, they follow the norms of declaration and see that peaceful declaration of the dispute should be resolved. So the declaration also contains the provision widening the role that the General Assembly actually or potentially could play as a forum for the consideration of the international dispute as well as for the consultation leading the peaceful settlement. So General Assembly has given the wide power and potentiality is there and to play a forum consultation role and to resolve the international dispute role and leading the peaceful settlement. So these are the roles are given by the General Assembly to resolve the disputes among the states by peaceful means. With respect to the Security Council, now when it comes to the Security Council, the declaration underlines its primary role in accordance with the Charter in the area of the settlement of the dispute or any situations the continuance of which is likely to endanger the maintenance of the internal peace and security. Even the Security Council also given such a mandate to see that a dispute can be resolved, which is likely to endanger the maintenance of the international peace and security. If it is not resolved, then the situation endangers the maintenance of the internal peace and security, and hence it should be taken into the hand and see that solution will be come out among the states for the peaceful resolving the disputes. A specific provision stresses the obligation under the Article 37 of the Charter of the Member of State to refer to the Security Council such a dispute to which they are parties if they fail to settle it by the means of indicated in the Article 33 of the Charter. The text further recommends making greater use of the fact-finding capacity of the Security Council in accordance with the Charter, and suggestion whose actuality should not be underestimated. In case the Security Council did not resolve it, let us presume it, but a Security Council have a right to fact-finding capacity. They can send the troops they send their body to see the fact-finding capacity of the Security Council, and thus they will come out with the truth and the dispute will be resolved in a peaceful manner. So the declaration further emphasizes that the state should be fully aware of the role of the International Court of Justice, which is the principal judicial organ of the United Nations for the settlement of the legal disputes among them. If the matter is not resolved with the Security Council, if the matter is not resolved with the Assembly, if the matter is not resolved by the sub-organs of the Security Council and the General Assembly, if the matter is not resolved by the Manila Declaration, then the last resort judicial organ. Which is the judicial organ of the United Nations? Participants.
The International Court of Justice.
I appreciate. It is only one organ which is outside the New York, but all organs of 5 would be there in the New York. The International Court of Justice situated in the Netherlands, and the place is called The Hague. In the palace, it is there. So now, for the settlement of the legal disputes, among them the last resort for the judicial organ is ICJ. Of course, the emphasis does not affect the possibility of the parties to dispute to choose another judicial organ for the settlement of the dispute. If the party agreed over there, let it choose another organ also. That is like wish. But if any organ will not agree with the thing, means the judicial organ will solve the problem. In accordance with the fundamental principle of the free choice of means, even the parties can select those who are the disputes. Even they can select the good office. He can select any country to come and resolve the issue also. So, furthermore, with the intent to strengthen the role of the International Court of Justice, which is a judicial organ, the declaration invites the state to recognize as a compulsory the jurisdiction of the International Court of Justice. Definitely, because all the members of the United Nations are also the members of the Manila Declaration. When such a thing would be there, then it is a binding on them. Of course, except the non-aligned countries. They don't come under the power. They say, no, we want to have their own dispute, settlement issues and organs are a different way. So, in accordance with Article 36 of the statute, are to insert the treaties wherever the appropriate clauses providing for the submission of the International Court of Justice of disputes which may arise from the interpretation or the application of such treaties. So now, asante sana sikiliza darasa. Mungu akubariki na kukulinda.